Hello friends, I am Sujatna Mudgal. Here I am going to present another interesting and learning episode of Forensic Psychology. Entitled as Basics of Forensic Psychology Part 2. The expert of this topic is Dr. Gyanesh Kumar Tiwari, Assistant Professor, Department of Psychology, School of Humanities and Social Sciences, Dr. Hari Singh Gaur University, Sagar, Madhya Pradesh in India. In this episode, I will discuss the assessment of mental competency, followed by the relationship between mental disorders and forensic psychology. I will also discuss in-length psychology of evidence. Lastly, the issue of psychology in the courtroom with a special reference to Section 84 IPC will also be covered. The episode will end with the major conclusions regarding the above issues. The presentation in this episode will follow the following sequence. Module 1, Assessment of Mental Competency. Module 2, Mental Disorders and Forensic Psychology. Module 3, Psychology of Evidence. Module 4, Psychology in the Courtroom with a special reference to Section 84 IPC. Module 5, Conclusions. Module 1, Assessment of Mental Competency. Let's start the discussion with the meaning and role of mental competency. Before the assessment, according to Black's Dictionary, the term mental competency applies to person's mental ability and choosing right from wrong and having the ability to express themselves. Mental competence is decision specific and concerned with an individual's ability to take part in legal proceedings and determines his/her responsibility for his or her decisions or acts. It represents psychological and moral integrity which are assumed to be essential for a person to carry out medical decisions involved in contractual agreements and other legal interactions. This mental competency has many legal applications in criminal, civil and administrative cases and act as an important ground for determining the responsibility and validity of decisions and involvement having multiple consequences, affecting the persons, groups and societies. Now I will move to the definition of mental competency to make it more comprehensive. Definition of mental competency. Guthail and Applebaum 2000 have divided competency into two types: competence to make decisions and competence to perform an act. Due to contradictions about the meaning and definitions of competency, legal professionals, medical professionals and psychologists employ definition of competence that is specific to certain populations, settings and circumstances. The former focus on the 5 basic issues in determining the decisional competency of the person. They are: first one is the individual's ability to make and express choice about his life. Second is the responsibility of the choices. Third one is the rational basis of his choices. Fourth is the ability to understand the personal implications of choices by the individual, and the last is the understanding of the implications of choice about his or her life by the individuals. Functional ability model of competence focus on the ability to perform functional acts within a specific and current context, which is understood to be an individual's competence or incompetence to participate in decision making. Simmer and Qualis, 1996. The issues regarding the functional ability emerge when there are safety concerns regarding an elderly person with a cognitive or physical disability. The degree of congruence between an individual's functional ability and the demands of the environment is pertinent for making judgment. Wells, 1996. The nature and extent of legal treatment is virtually dependent on an individual's mental competence. In many cases, forensic psychologists are appointed by the competent court to examine and assess the mental competency of an individual to stand trial, and thus the recommendations of the forensic experts are important for the court to decide the role of the defendant to stand up for the trial. The measure to be taken to make able the defendants are also recommended by the forensic experts in consultation with other mental health professionals such as psychiatrists. Thus, it aims to restore the individual's competency to understand the court and legal proceedings as well as participates appropriately in their protection. Now, we will proceed to discuss the methods of assessment of mental competency. Methods of assessment of mental competency. The above discussion makes it clear the mental competency is important for an individual to declare himself or herself fit for the trial, to testify as a witness and responsible for other legal acts in criminal as well as civil proceedings. There are 4 basic methods through legal insanity of an individual is determined. The first one is the M. Norton rule in 1843. Daniel M. Norton, an Englishman, was found relief due to his ill mental health in the case of murder, the secretary of the Prime Minister, and after his name, the rule is being applied to determine the insanity of the individual in criminal cases. According to this rule, a defendant is deemed to be legally insane if he or she was unaware of what he or she was doing at the time of committing offence, or unable to understand this doing was wrong. The second rule is the irresistible impulse test. This test applies where a defendant may be aware of wrongness of his or her actions, but the crime was committed due to an irresistible impulse. This test is used along with the M. Norton rule, which focus on the violation of the defendant. In essence, the test allows for a defendant to be found not guilty by reason of insanity if this of her mental illness mean that although recognizing the wrongness of the offence, he or she was compelled to commit the offence anyway. The third rule is the Durham rule. In Durham rule, the emphasis is placed by psychological evaluation and evidence reached through the diagnosis made by trained professionals to determine the guilty of the accused. This test less used today as it takes much of the decision-making abilities out of the jury and places it in the hands of psychologists. The fourth rule is the model panel code. The model panel code is much broader than the comparative inflexible M. Norton rule. It attempts to incorporate the importance of violation of the defendant that is assessed by the irresistible impulse test. It also prohibits psychopaths and sociopaths from using the insanity of defense. These tests are very important in assisting a court to determine the legal insanity claim of a defendant at the time of committing crime and ensure fairness of the criminal justice system. Where the cases of severe mentally illness are involved, it is evident that the psychologists have a very significant role in the ascertaining mental competence of a person, which has the direct and important consequences with both beneficial and devastating impacts on the life of the person. According to another approach, mental competence can be assessed by applying multiple criteria involving the conditions which cause mental dysfunctions. Moore 1999, Simmer and Qualis 1999. The approach is directed to portray accurate the functional ability of the individual and assist in determining the ability of the individual in meeting and demands of the environment. Most of the researchers agree about the specific cognitive ability that deserve to be part of any competence evaluation. These criteria involve orientation, reasons and remote memories, intellectual capacity, attention and judgment. Cap 1996. For example, mathematical ability of the individual may be assessed in those cases where financial ability to manage the finances is questioned, which may be affected by the normal process of aging and mental health conditions. Now we will discuss in sufficient detail the relationship between mental disorders and criminal behaviors. In the next module, that is module 2, mental disorders and forensic psychology, normal aging is characterized by certain psychological, cognitive and behavioral changes which are assumed to be helpful in competency evaluation and by that way useful in ascertaining the defendant's ability to stand trial. In this section, I will discuss these changes along with certain mental health conditions which are necessary to fix the role of defendant. The normal aging is characterized by several structural changes in brain, its weight and an enlargement of the ventricles. Winters 2001. It has been reported that 7 to 10% of the brain weight exhibit declining trends after the age of 65 with the rate of 2 to 3% per year. Powers 2000, Winters 2001. These results in tissues loss in major proportion of brain in the form of construction of gyri and enlargement of sulci. Martin and Rubin 1997. The frontal and temporal lobes exhibit greater weight loss followed by hippocampus, basal ganglia and thalamus. Powers 2000. In addition, neural death, the shrinkage of the larger neurons and declining synaptic density begin after 60. Martin and Rubin 1997, Powers 2000. Decline in many intellectual functions have been observed with the age in the form of decreased ability to perform on the task demanding speed. The researchers have come up with the findings that some changes in the memory are related with non-pathological aging. It has been found that the older adult perform at lower levels than younger adults on short-term memory tasks involving working memory, Beckman, Small and Vaughan 2000, which more pronounced in the case of complex tasks, Setholzis and Babcock 1991. The researchers have also reported that the long-term memory, semantic memory and the procedural memory are generally unaffected by the age. Zarit and Zarit 1998. With the exception that these episodic memory declines with the age which start at early adulthood, Blackman and Small and Vaughan 2001. There are many mental disorders which are associated with the mental competence. Dementia is one of such disorder which is genetic term denoting an acquired syndrome characterized by progressive decline in several areas of intellectual functioning, which significantly affect the social or occupational functioning of an individual. Richman 2000. About 6 to 10% population above age 65 are affected by this disease, which varies on the causes. Criteria and definition of the disease, Hender 1997. In addition to memory deficit, many other changes in cognitive processes and functioning are also associated with dementia, such as poor language ability, that is aphasia, anomia, that is impaired naming and diminished verbal fluency, Zek 1993, and impaired ability to draw or manipulate objects, Miller and Gosteven 2000. The changes in executive functioning or higher order cognitive ability such as judgment, problem solving and abstract thinking also exist with the dementia, that is also said by Zek 1993. There has been a long debate over the role of mental disorders in committing various sorts of criminal activities among researchers, that is said by Lombarzo 1911, Mohanam 1981. During 1960s and 1970s, it was argued that any correlations between mental disorders and offending might be the result of the confounding influences of the social disturbances accompanying disorder and disability. Mohanam and Stuitman 1983, Mulan 1984. By 1980s and 1990s, it was reasoned by the psychiatrist and the psychologist that these exist correlations between serious mental disorders and offending behaviors. Hodgins 1992, Moonaham and Steedham 1994, Mullin 1997, Toure 1994. Which emphasized causal the theories based in neurological and pathologies and genetic variations in place of social and psychological constructions of mental disorders. An initial comprehensive study by Hafner and Booker 1982 revealed that there exist correlations between having schizophrenia and violent offenses. They also came up with the conclusions that a tendency to aggressive behavior is rooted in the personality and in the mentally abnormal, such as tendency has usually become manifest long before the onset of the psychosis. At present, there is a sufficient body of research based on the multiple methodologies which conclude that the significant correlations between different forms of mental disorders and a range of offending behaviors exist. Many studies have examined rates of violent and criminal behaviors in mentally disordered and impaired individuals. That is said by Walker and Selfried 1994, Binder and McNeil 1988, the MacArthur collaboration represents the most sophisticated examination with the objective to examine the relationship between a mental disorder and violent and criminal behavior. Monahan et al. 2000. Based on the self-report of a sample of more than 1,000 people admitted to public psychiatric inpatient facility in Pittsburgh, Kansas City and Worcester, Massachusetts, the study concludes that the overt act of violence occurred in 27.5% of the subjects exhibiting the criminal behaviors ranging from hitting to attacks with weapons. The persons with depression, schizophrenia and other psychotic disorders were less likely to overtly violent than those suffers from personality or adjustment disorders. The higher violent behaviors were recorded for those who were found to show substance abuse. This study concluded that the patient with major mental disorders but without substance abuse were no more likely to be violent than others in their neighborhood without symptom of substance abuse. A recent study by Mullen et al. 2000 traced the criminal theories of 1,000 people with the diagnosis of schizophrenia who had been admitted either 1975 or 1985. It was reported that more than 20% of the males with schizophrenia had been convicted of a criminal offense, with over 10% having a conviction for violence compared to 8% of controls who has a recorded offense with 2% violent conviction. A coexisting diagnosis of substance abuse was significantly associated with the chance of acquiring a conviction, 49% versus 8.6%, including convictions for violence, that is 17% to 2%. There has been numerous studies of the rates of mental disorders among offenders populations, usually focusing on prisoners. A study of a representative sample of sentenced prisoners in England and the Wales reported rates of schizophrenia for males of 1.5% and females is 1.1%. Gunn et al. 1991, Taplin 1990, in an American study of 728 remandees ascertained 6.4% to have severe mental disorders, of whom nearly half had schizophrenia, which was twice the rate ascertained in the general population. The study of Tyler and Gunn 1984 employed the present state examination to establish the level of psychopathology in 1241 remand prisoners and found that 9% of those convicted of non-fatal violence and 11% convicted of homicide and schizophrenia in males. Affective psychosis, affective disorders and personality disorders were moreover represented among offenders in general and violent offense, including homicide in particular. Wallace et al. 1998. Those males who had been diagnosed with schizophrenia and had also received a diagnosis of coexisting substance abuse were over 12 times more likely to be convicted than a member of the general population, compared to less than 2 for those without a substance abuse diagnosis. It can be concluded that above discussion that the prisoners have generally exhibit a wide range of mental disorders, the high rate of criminal behaviors to occur in case of the person with mental disorders, 2 to 4 times with substance abuse. It can be also observed that the level of psychopathology among women prisoners are even greater than the male inmates. The community studies showed that as compared to normal criminals, there was 12% more chance of the committing crime in the case of person suffering from schizophrenia and major depression. Swanson et al. 1994. The recent study have also come up with the conclusion that mental disorder are also associated with an increased likelihood of the arrest for violence. Barron et al. 2000. And when demographic factors and comorbid substance abuse were controlled for individuals hospitalized for schizophrenia, had significantly higher rate of arrest for violence. The relationship of offending behavior and intellectual disability has also been studied. The studies have reported that offender groups contain more individuals with low IQs. Hayes and McIlvaine 1988 Hirsch and Hendelin 1977. It is estimated that the prevalence of intellectual disability in the general population is 2 to 3%, whereas the condition is prevalent at least 12 to 13% in the case of prisoners. Goodsgone et al. 1993, NSW Law Report Commission 1996. It has also been found that the children with the lower IQ are more prone to the conduct disorder and delinquency than those with average or above scores on intelligence test, Moffitt 1990. There is also an association between offending behavior and brain damage of the offender. The person with brain damage, particularly injuries to the frontal lobe, and associated with increased level of violent behavior. That is said by Nodophil 2000. The degenerative brain disorder of old age can also be associated with aggressive and on occasion seriously violent behavior with such behavior. Eastley and Wilcox's 1997. Epilepsy has been held to be associated with criminal behavior. Epilepsy is found more frequently among prisoners. That is said by Tooney 1990. The community study of the crime and mental disorder observed elevated rate of various forms of violence, Buran et al. 2000. In the next module, we will discuss in short the role of the forensic psychologist in providing evidence to the court. Module 3, Psychology of Evidence. Evidence play an important role in the modern legal system, which require an expert of a group of experts who extended their statement or opinion on any admissible matter calling for expertise by witness and if qualified to give such an opinion to the court. It gives independent assistance to the court following objective and unbiased opinion in relation to matters within their expertise. The expert evidence aims to assist the court having a relevant expertise with impatient intention. The evidence of the expertise must give detail of the expert's qualification, relevant experience and accreditation along with the literature or other information which have been relied on making the report. The evidence must contain the substance of all facts given to the expert with the expert's own knowledge along with the detail of the examination measurement, test of experiment with the reasons of the opinion. The expert assessment and evidence is useful in many sorts of the legal matters. Its significance can be explained in the following words. The first is family law, second is the matter before the Social Security Appeal Tribunal to the Administrative Appeals Tribunal. Third is the assessment of fitness to be tried, pre-sentence reports, assessment for bail or parole, assessment or whether or not a defendant mental abnormality is available to the client. Fourth is the victim's compensation guardianship and protect estate. Fifth is the ability to enter into a contract, compensation for accident and injury, competence to make a will, and sixth is the competence to be a witness. Seventh one is the psychological evaluation of the fitness to be tried or ability to understand the police caution and to comprehend the right to silence. On the basis of the qualifications, skills and training of the psychologist, they give evidence about particular aspects of human behavior which consist of cognitive functioning or receptive and expressive language. The evaluative function of the forensic psychologist overlap with those of the psychiatrist, neuropsychologist, occupational therapist, speech pathologist, social worker and in some instances nursing staff or caregiver in the community health system. The evidence or testimony of the psychologist lies in the administration of psychological tests which are based on the logical compensations of the given facts, which is population and previous levels of functioning of the clients. To accomplish the above mentioned duties, the forensic psychologist must be flexible, knowledgeable and expert in many areas as well as have familiarity with the limitations of their knowledge, skills and interpretations based on the psychological assessment, owning of the diversity of the specialized areas, Singer and Nivot 1987 have suggested that it is a complex art to become a useful consultant and effective expert witness, as it required evidentive knowledge of psychology and the law. He must be able to articulate in interesting and believable style with the ability to explain technical and theoretical concepts in an understandable manner. In addition, the psychologist must have the ability to establish rapport with the client to obtain the best and most accurate test result in the given period of time. According to Kraft 1984, a professional report of witness expert must contain the following. The first is the fact with their supporting evidence. Second is the professional's deduction from the fact which amount to an opinion. Third is the recommendation for action. Thus, the most important aspect of psychological evidence is the ability to provide the court with norm reference results based upon standardized psychological assessment. The clinical interview and the expert opinion can draw together and illuminate the test result, but basically the test results themselves stand alone. The expert must keep in mind the facts that even court and sometimes lawyers express distrust over the expertise and their role. Lastly, we will discuss in very short the provision of punishment in section 84 of IPC and the role of the psychologist. So, there is module 4, psychology in the courtroom, with a special reference to the section 84 IPC. According to the section 84 Indian Penal Code, that is IPC, nothing is the offence which is done by the person who at that time of doing it by reason of unsoundedness of mind is incapable of knowing the nature of the act, or that he is doing what is either wrong or contrary to law. Thus, this is the primary legislation dealing with the criminal responsibility of mentally ill persons in India. In legal terms, the responsibility refers to the liability to punishment, which is fundamental to the view of man as a free and intentional being. As per the modern legal principles, a person can be held liable for any act of commit the crime with his wish and free will. Thus, motive is important for a criminal act. In other words, a mentally ill person is not punished for his crime, as he is devoid of free will, intelligence and knowledge of the act. If the question of mental illness arises in the legal processes, the accused can be sent to prison, psychiatric hospital, any other place of safe custody, or they may be acquitted. This provision may prove dangerous as well as criminal will plead defense of insanity in order to avoid punishment. The discussion makes it evident that the role of psychologist is very crucial, as the decision regarding the insanity of a criminal lies in their hands as the mental health expert. So, there is module 5, that is conclusions. Thus, so far we have discussed the mental competence, which refers to a person's mental ability and choosing right from wrong and having the ability to express themselves. It also represents psychological and moral integrity, which are assumed to be essential for a person to carry out medical decisions involving contractual agreements and other legal interactions. In the second module, we discussed 4 methods of the assessment of mental competency: the M. Norton rule, the irresistible impulse, test the Durham rule and the model penal code. Another approach emphasizes the use of a multiple criteria involving the conditions which cause mental disorders. These criteria involve orientation, recent and remote memory, intellectual capacity, attention and judgment, as said by Cap 1996. Mental disorders have been reported to be associated with the commitment of many types of criminal behaviors. Abnormal behaviors occurs as a result of aging, which induce many regressive changes in the physiological, cognitive and behavioral aspects of, including several structural changes in the brain, its weights and enlargement of the ventricles. Dementia is one of the generic term denoting an acquired syndrome characterized by progressive decline in the several areas of intellectual functioning, which significantly affects the social or occupational functioning of an individual, and has been found to be associated with criminal behaviors. The researchers have agreed that there exists correlation between serious mental disorders and offending behaviors. An initial comprehensive study by Hefner and Booker 1982 revealed that there existed correlations between having schizophrenia and violent offences. It was argued that the tendency to aggressive behavior is rooted in the personality and in the mentally abnormal, such as a tendency has usually become manifest long before the onset of the psychosis. At present, here is a sufficient body of research based on multiple methodologies which concludes the significant correlation between different forms of mental disorders and a range of offending behaviors exist. The witness experts give their statement or opinion on any admissible matter, calling for expertise by the witness and the qualified to give such an opinion to the court. It gives independent assistance to the court following objects and unbiased opinion in relation to matters within their expertise. The expert evidence is permissible law to assist the court having relevant expertise with impartial intention. The section 84 of Indian Penal Code provides that a person cannot be punished if he or she was unsound in mental health at the time of committing crime. It is the primary legal provision which deals with the criminal responsibility of mentally ill person in India. With all this information, here we come up to the end of today's lecture. Do keep in mind what we discussed today. It is time for you all to do some self-study. This is Sujata Mudgal signing off. If you want to learn more and enhance your knowledge, you may log on to our website, MCQ, quizzes, LORs, www.cec.nic.in. Till then, goodbye.